Hello, everybody, and welcome back to Civics. Today we'll be doing a Civics special on judicial review, the Roe v. Wade case, and Supreme Court partisanship, which has become a much more prevalent issue in the last couple of decades. Now, the reason we're having this special is because of the leaked Supreme Court draft decision that was released a week or two ago concerning the case Roe v. Wade. Basically, this draft opinion states that the conservative majority on the court is going to be overturning Roe v. Wade, and it kind of gives us a glimpse into what their reasoning is going to be. This is the first time that an entire draft decision has been leaked before, so that means that this is kind of an unprecedented time for the court, because they usually operate in secret. We don't actually know what's going to happen until they release their decisions. So this is a first in our nation's civic history. So we're going to talk about a little bit what's happening, why it's happening, and what it might mean possibly for the future of the court and the country as we go forward when this decision actually is eventually released, the full decision, and it's made official. So first of all, let's start talking about what exactly it is that this draft is doing, and if it becomes official, what it'll do. Basically, the court in this instance is exercising what is called judicial review. Judicial review is established during Marbury versus Madison, and it gives the Supreme Court the right to interpret the Constitution and decide whether law is constitutional or not. So it's a power that the Supreme Court gave itself in 1804 in an old case. This has allowed them to overturn law or precedent that they seem to say is no longer in the essence of what the Constitution is supposed to be. This has been used many times over the course of American history, and in this case, they would be overturning precedent. There is no official federal law that codifies Roe v. Wade. Roe v. Wade is a court decision, so in this case, they would be overturning precedent. Precedent, of course, being the basically legal history. So they're saying all these old cases that said that this was okay, that's not actually okay. There are plenty of cases that have done that. The two most famous ones that maybe you'd be most familiar with might be Brown versus the Board of Education, which said that separate was no longer equal. That was a precedent set by an earlier Supreme Court case. So Brown v. Board overturned precedent. And then also Citizens United, which overturned a lot of campaign finance law decisions, laws, etc. So that also overturned precedent dealing with campaign finance. So basically, they're trying to reestablish an interpretation of the Constitution in this particular case. That's what the Supreme Court is doing, this conservative majority. Now, what are they trying to overturn? Well, the precedent that they're trying to unestablish is the establishment of the right to privacy that has been accepted into the interpretation of the 14th Amendment. The 14th Amendment is an amendment that guarantees civil liberties, and although it's not explicitly stated in the amendment, it has been accepted since around the 1920s that the 14th Amendment gives a relative broad right of privacy to citizens in the United States in regards to procreation, child rearing, marriage, medical treatment, all those different things. So basically, since the 1920s, the Supreme Court has upheld that even though it doesn't specifically say in the 14th Amendment you have a right to privacy in this instance, they're saying that based on what the court finds, legally you do have this right, thanks to the 14th Amendment. So that's what the conservative majority on the court is trying to do. They're trying to overturn that precedent, and they're saying, well, actually, that shouldn't be there. It doesn't say it in the Constitution, so that right to privacy doesn't exist. So specifically, right, they're overturning Roe v. Wade, which you all kind of know as the abortion case. Roe v. Wade made it legal for abortion to happen in all 50 states, saying that women had the right to make that choice. They had a right to privacy in their medical matters, right, which is kind of that broad right of privacy from the 14th Amendment. And so states could not restrict that, right, because it's saying that at a federal level it's protected under the Constitution. The consequences, of course, right, being that that abortion access was granted throughout the country. Now, the other consequence to that, of course, is the people who did not like that decision now had something to fight against. So they've, for the last 50 years now, been trying to overturn Roe v. Wade. Now, basically what that's been in practice are state governments passing restrictory laws on abortion and seeing what the Supreme Court is willing to strike down or allow. And so over the course of the last 50 years, different states have passed different regulations and laws and restrictions trying to see what is allowed and what is not allowed under the interpretation of Roe v. Wade. Most recently, right, there have been more and more states basically passing these restrictions, seeing how close they can get to banning abortion. These heartbeat bills, the 6-week bans, all these sorts of things are part of that 50-year process of attacking this case. So, where does that really leave us? Well, this leaked draft is not official because it's a leaked draft, right? It is not an official decision of the Supreme Court yet. But what this means is that within the next few months, it can be finalized, and that majority could then repeal the protections of Roe v. Wade using the legal arguments within it. And we'll explain those legal arguments a little bit more in a second. What makes this particularly bad, though, is that in the most recent decade or so, the Supreme Court has been attacked by partisan demands. For instance, the most recent 3 Trump appointees, Garush, Coney Barrett, and Kavanaugh, all were made Supreme Court justices, which is a lifetime position. And we're learning more and more that potentially that the president who was appointing these people wasn't following the rules. So that's not particularly great. That being said, Mitch McConnell, the Senate Majority Leader, also didn't really follow the rules and refused to give Obama's final Supreme Court seat a hearing, despite the fact that he allowed Coney Barrett to be made a Supreme Court justice in the last month of Trump's presidency when we knew he wasn't going to be president anymore. So this political posturing has really kind of damaged the integrity of the court. These Supreme Court justices were put in place maybe in not the greatest terms, right, with potentially with a president that maybe doesn't have the actual legal authority to do so. And then, of course, there is McConnell doing some maneuvering to make sure that they got the majority on the court. Of course, there's also the fact that Clarence Thomas, one of the older members of the court, his wife is connected to the January 6th insurrection, which if you've been watching the news, you would know that his wife, Ginny, was texting with people in charge of that attempt to violently overthrow an election, making him kind of a black sheep on the court as well. He should maybe not be there because of the political partisanship that has been invoked thanks to his wife. So with all that together, let's talk about a little bit about what this draft is actually trying to do. So first of all, in the most basic terms, it's just trying to overturn the precedent of Roe v. Wade. They don't want to restrict it and make it so that states have the choice to ban abortion if they want to. Basically, their legal argument in this case is two-parted. One, it says the 14th Amendment does not actually provide the right to privacy I mentioned earlier. It's not written in the amendment, so it's not there. There are originalists saying that they go by the exact words of the amendment, which means, since it's not an explicit thing written in the amendment, it's not there. So they're saying, hey, not written in the amendment, no right to privacy, which affects all sorts of other things. 2, they're saying there's no historical protection for this sort of thing. Basically, what they're saying is that when the Constitution was written, women didn't have rights, and because of that, they don't deserve them now, basically, is the gist of that part of their argument as well. So it's two-pronged. One, it's not explicitly written in the Constitution that you get a right to privacy. 2, women don't traditionally have rights over these things, so they shouldn't have them now, is the gist of their legal argument in this draft opinion. And this means, with that legal interpretation, that means that they could use that exact legal precedence that they're creating in this case to overturn other cases, like the case they granted that made gay marriage legal throughout the entire country. They could overturn Loving, which allowed interracial marriage. They could say, well, that protection wasn't there traditionally, so it doesn't mean it shouldn't exist. They could overturn trans rights and the rights to medical care for trans people. They can get rid of other rights for women, such as the ability to get contraception, the ability for them to have financial freedom. All those things can get taken away. So there's a whole myriad of other issues that are being opened up by them going after this specific case. So to kind of conclude what exactly is happening here, they're trying to set a dangerous precedent of saying that legally, since certain groups have not had rights in the past, they don't deserve to have rights now. So any right that's not explicitly stated in the Constitution is potentially under attack here that these people don't like. They are going to use their ability to establish new precedent to basically say that if you didn't have rights in 1776 or in 1787, then good luck getting them now. This has been a long, long fight for this particular group of conservative firebrands, I guess is a good word for it. This is also not good because it's an attack on bodily autonomy. It's basically saying that women don't have the rights to make choices about their bodies, and that means those decisions should be made by men. And that's absolutely ridiculous, since we give a lot of bodily autonomy rights to dead people, right? You can't have medical procedures done on your body if you're dead. You can't have your organs donated automatically if you die. You have to give permission for those things. But we're saying that a woman who's alive doesn't get to say whether or not she wants to have a baby or not. So if you just look at it directly in the realm of bodily autonomy, right, we are restricting the rights for women, and we give more to dead people. And then finally, this whole thing weakens the legitimacy of the Supreme Court, which has already been weakened by the political posturing of the Republican Party. So they've used partisanship and sneaky tricks to create a majority for this lifetime body that can't be held accountable as easily as Congress or the president. And now they are using the power that they have to overturn half a century of legal precedent so they can do whatever they want. And the worst thing, of course, is that 70% of the population doesn't think that this is something that should happen. So they're basically overturning the will of the people, which, as we've talked about on this show a lot, is the fourth branch of government, the people. So as this situation develops, we might come back and talk about it some more. But for right now, that's kind of a basic rundown of what's happening with this leaked Supreme Court document. I hope you learned something and it's inspired you to look into it more. And we'll see you next time. We have a special Civics. Thanks again for watching, and we'll see you soon.